9. 2016 meeting between senior campaign officials and a Russian attorney. On June 29th, Hicks warned the president that the emails setting up the June 9th meeting were really bad, and the story would be massive when it broke. But the president told her and Kushner to leave it alone. Early on July 8th, after Hicks told the president the New York Times was working on a story about the June 9th meeting, the president directed her not to comment, even though Hicks said that the president usually considered not responding to the press to be the ultimate sin. Later that day, the president rejected Trump Jr.'s draft statement that would have acknowledged that the meeting was with an individual who I was told might have information helpful to the campaign. The president then dictated a statement to Hicks that said the meeting was about Russian adoption, which the president had twice been told was discussed at the meeting. The statement dictated by the president did not mention the offer of derogatory information about Clinton. Each of these efforts by the president involved his communications team and was directed at the press. They would amount to obstructive acts only if the president, by taking these actions, sought to withhold information from or mislead congressional investigators or the special counsel. On May 17, 2017, the president's campaign received a document request from SSCI that clearly covered the June 9th meeting and underlying emails, and those documents also plainly would have been relevant to the special counsel's investigation. But the evidence does not establish that the president took steps to prevent the emails or other information about the June 9th meeting from being provided to Congress or the special counsel. The series of discussions in which the president sought to limit access to the emails and prevent their public release occurred in the context of developing a press strategy. The only evidence we have of the president discussing the production of documents to Congress or the special counsel is the conversation on June 29, 2017, when Hicks recalled the president acknowledging that Kushner's attorney should provide emails related to the June 9th meeting to whomever he needed to give them to. We do not have evidence of what the president discussed with his own lawyers at that time. B. Nexus to an official proceeding. As described above, by the time of the president's attempts to prevent the public release of the emails regarding the June 9th meeting, the existence of a grand jury investigation supervised by the special counsel was public knowledge, and the president had been told that the emails were responsive to congressional inquiries. To satisfy the nexus requirement, however, it would be necessary to show that preventing the release of the emails to the public would have the natural and probable effect of impeding the grand jury proceeding or congressional inquiries. As noted above, the evidence does not establish that the president sought to prevent disclosure of the emails in those official proceedings. C. Intent. The evidence establishes the president's substantial involvement in the communication strategy related to information about his campaign's connections to Russia and his desire to minimize public disclosures about those connections. The president became aware of the emails no later than June 29, 2017, when he discussed them with Hicks and Kushner, and he could have been aware of them as early as June 2, 2017, when lawyers for the Trump Organization began interviewing witnesses who participated in the June 9th meeting. The president thereafter repeatedly rejected the advice of Hicks and other staffers to publicly release information about the June 9th meeting. The president expressed concern that multiple people had access to the emails and instructed Hicks that only one lawyer should deal with the matter. And the president dictated a statement to be released by Trump Jr. in response to the first press accounts of the June 9th meeting that said the meeting was about adoption. But as described above, the evidence does not establish that the president intended to prevent the special counsel's office or Congress from obtaining the emails setting up the June 9 meeting or other information about that meeting. The statement recorded by Corallo that the emails will never get out can be explained as reflecting a belief that the emails would not be made public if the president's press strategy were followed, even if the emails were provided to Congress and the special counsel. H. The president's further efforts to have the Attorney General take over the investigation. Overview. From summer 2017 through 2018, the president attempted to have Attorney General Sessions reverse his recusal, take control of the special counsel's investigation, and order an investigation of Hillary Clinton. Evidence. 1. The president again seeks to have Sessions reverse his recusal. After returning Sessions' resignation letter at the end of May 2017, but before the president's July 19, 2017 New York Times interview, in which he publicly criticized Sessions for recusing from the Russia investigation, the president took additional steps to have Sessions reverse his recusal. In particular, at some point after the May 17, 2017 appointment of the special counsel, Sessions recalled. The president called him at home and asked if Sessions could unrecuse himself. According to Sessions, the president asked him to reverse his recusal so that Sessions could direct the Department of Justice to investigate and prosecute Hillary Clinton, and the gist of the conversation was that the president wanted Sessions to unrecuse from all of it, including the special counsel's Russia investigation. Sessions listened but did not respond, and he did not reverse his recusal or order an investigation of Clinton. In early July 2017, the president asked Staff Secretary Rob Porter what he thought of Associate Attorney General Rachel Brand. Porter recalled that the president asked him if Brand was good, tough, and on the team. The president also asked if Porter thought Brand was interested in being responsible for the special counsel's investigation and whether she should want to be Attorney General one day. Because Porter knew Brand, the president asked him to sound her out about taking responsibility for the investigation and being Attorney General. Contemporaneous notes taken by Porter show that the president told Porter to keep in touch with your friend in reference to Brand. Later, the president asked Porter a few times in passing whether he had spoken to Brand, but Porter did not reach out to her because he was uncomfortable with the task. In asking him to reach out to Brand, Porter understood the president to want to find someone to end the Russia investigation or fire the special counsel, although the president never said so explicitly. Porter did not contact Brand because he was so sensitive to the implications of that action and did not want to be involved in a chain of events associated with an effort to end the investigation or fire the special counsel. McGahn recalled that during the summer of 2017, he and the president discussed the fact that if Sessions were no longer in his position, the special counsel would report directly to a non-recused attorney general. McGahn told the president that things might not change much under a new attorney general. McGahn also recalled that in or around July 2017, the president frequently brought up his displeasure with Sessions. Hicks recalled that the president viewed Sessions' recusal from the Russian investigation as an act of disloyalty. In addition to criticizing Sessions' recusal, the president raised other concerns about Sessions and his job performance with McGahn and Hicks.